Good evening. I welcome one and all in our function today, our fifth iteration of BBA ATC training module. We are delighted to have with us my Lord Justice G.S. Patel. May I request Mr. Thakkar, our President, to give his welcome address and commence with today's ceremony.
The Honorable Mr. Justice Gautam Patel, Mr. Kanade, Secretary, Bombay Bar Association, Mr. Farhan Dubash, Chairman of the ATC Course Committee of Bombay Bar Association, all the trainers, members of the Standing Committee of BBA, and all the participants for the 5th year's course of training course, ladies and gentlemen. It gives me immense pleasure to welcome Justice Patel for inauguration of the 5th Advocacy Training Course conducted by the Bombay Bar Association. A very special thanks to His Lordship for having accommodated us for the inaugural ceremony, as we were very keen to have him to inaugurate this course, and very kindly he has agreed to give today's date. So thank you very much, sir, for taking the time to be present today and for agreeing to address our trainers and participants of the course, all of whom shall undoubtedly immensely benefit from your insights. The advocacy training course was started by the Bombay Bar Association in collaboration with International Advocacy Training Council in November 2021, when the first batch of our faculty was trained by international trainers. We have as on date, as part of our faculty, almost 40 trainers, and we intend to add more trainers very soon. Since January 2022, when the first training course for young lawyers was held by us, over 160 participants have received training, and the trainers are all set to train 30 more participants in this course. Having been part of and witnessed the inception of the course, I take immense pride in the way it has been shaping up. I would here like to specially thank Ms. Namrata Shah, our member who introduced the members of the International Advocacy Training Course to the Bombay Bar Association and played a pivotal role in setting the course up. This course has also brought about admin skills of our members, as was demonstrated by Mr. Farhan Dubash, Namrata Shah, Mahek Bukwala, Akash Ribelo, and Sneha Fene, who have successfully helmed previous and present edition of the course. So thank you very much, all of you. To my young friends who are participating in this course, I am so very glad that all of you have been so enthusiastic and eager to learn. Our past experience tells us that the participants have found immense value in the course. As I have said earlier, I envy my young friends who today have this opportunity to be part of a structured training course in trial advocacy. When we started out, we were mostly at sea and learned by watching our seniors conducting trials in court. But of course, today, when examination in chief is by affidavit and cross-examination happens mostly before a commissioner, the opportunities to watch and learn are few and far in between. And therefore, this kind of course, we hope, will help. Justice Patel's court is an exception to that rule because he has conducted, when he was sitting as a single judge, several trials in open court. Apart from the training that the young lawyers receive through this course, one great advantage of the course that I see is the opportunity for interaction among members of the bar, seniors and junior alike. Why just the Bombay Bar? In fact, in December last year, some of our trainers from Bombay flew down to Goa and conducted a training session in collaboration with Goa Bar Association, which was an excellent opportunity for advocates from Bombay and Goa to interact and share their experiences. Justice Sonak, who spoke about with some of the participants, informed us that they really found the training useful. Over the time, we hope to conduct 3 to 5 courses per year. And for this, we are really thankful to the Chief Justice who has been making available the courtrooms so that we can have an actual court-like experience while conducting this course. Hopefully, over the time, the trainees of today will become the trainers of tomorrow and will help to continue the healthy tradition of exchange of knowledge. Before I conclude, I would be failing in my duty if I don't recognize and appreciate the contribution made by the trainers who are taking time out from their busy schedules to make this course a success. So thank you very much, all of you. My dear trainees, I wish you all the very best. I hope the course quickens your step on the path to trial advocacy. Thank you very much.
Thank you, Mr. Thakkar. May I request our member, Ms. Neha Fene, to kindly give a bouquet to Justice Patel as a token of her affection. Also like to request our member, Ms. Fene, to give a brief introduction of this year's course before we call upon Justice Patel to give his address.
My Lord Justice Patel, Mr. Nitin Thakkar, President of the Bombay Bar Association, Mr. Vishal Kanade, Secretary of the Bombay Bar Association, Mr. Farhan Dubash, Chairperson of the BBA ATC, members of the bar, faculty members and participants. Good evening and welcome. First of all, I would like to thank Justice Patel for agreeing to inaugurate the course and to address the trainers and the participants. All of us are eagerly waiting to hear your Lordship. As Mr. Thakkar said, this is the 5th advocacy training course conducted by the Bar Association. So first, a quick background about the course. The faculty of this course is trained by the International Advocacy Training Council, or the IATC. Now, the IATC is an organization which is registered in Hong Kong, and this organization trains young lawyers in advocacy using a method called the Hampel method. So what the IATC does is it collaborates with bar associations across the world and helps them to set up their own individual advocacy training courses. And that is how the advocacy training course in Bombay was set up. The first batch was trained in November 2021, and the second batch was trained in December 2022 of the faculty. The trainers who trained the faculty were sitting judges. They were barristers, senior advocates from countries like Hong Kong, Singapore, Malaysia, UK, and South Africa. As part of the faculty, I can say that it is truly an enriching experience to interact with the international trainers and to learn to teach and even think in a structured manner. Personally speaking, being a trainer has helped me definitely to be a better advocate. And I'm sure that all members of the faculty would agree with me on this. This time around, when we opened registrations for the course, within 24 hours, we received over 100 registrations, though we had only 30 seats. I know that there are a lot of people who would be disappointed, but as our faculty expands, we will over time be able to hopefully take in more participants in every course. So what exactly is the nature of this course conducted by us? This is a 3-day course spread over 2 weekends. Participants are given course material for 2 cases. The first case is for conducting an entire trial and then conducting final arguments, while the other case is for an interim application where arguments are to be made. On day 1 of the course, that is 2nd February in this case, we conduct case analysis. Here, the trainers take the participants through the course material and they try and identify the reliefs, the elements of the cause of action, the dispute, the issues between the parties. What are the good facts for the plaintiff? What are the facts against the plaintiff? The aim is to enable the participants to understand as to what examination in chief needs to be conducted and what questions need to be elicited in cross-examination. And that sets the stage for day 2 and day 3, when the participants actually conduct examination in chief and cross-examination themselves and also make final arguments. Each participant's performance is reviewed by the trainers, and the trainers give them specific points on how they can improve. One thing I would like to tell the participants is, please do not be afraid to make mistakes. The trainers are not here to judge you. The course is meant to be a process where we help each other along to get better. So it is completely a safe space. Also, one thing which I would like to point out, in some of the earlier courses, some of the participants told us that, it is really nice that you're giving us this good feedback, but why don't you also tell us what, you're telling us what we did wrong, why don't you also tell us something good that we did? So I'd just like to say that the structure of the course is such, we are not trying to criticize you. The structure of the course is such that we are required to identify areas where you can do better. So the aim is to help you to do what you're doing in a better manner. And on a lighter note, if you don't make mistakes, then we are going to be very afraid, because then we'll have nothing to tell you. So I must end by thanking everyone who has made the present course possible. Of course, Mr. Nitin Thakkar, who trusted me enough to be the course director for the February course and kept encouraging me at every step. Mr. Vishal Kanade, who was always available for every little thing that we needed for the course. And of course, Ms. Namrata Shah. If she hadn't introduced the course to us in 2021, none of this might be happening today. Mr. Farhan Dubash, who gave me a free hand to conduct the course as I deem fit. Mr. Akash Ribello, who was always available at one phone call. The junior committee, Petras, Pooja, Pratik, Kashyap from the BBA. And of course, Ms. Mehak Bukwala. This is the file which Ms. Bukwala very painstakingly prepared after the last course and very sweetly handed over to me. And it is because of this file that she's given me and the help that she's given me at every step that organizing this course has been an absolute breeze so far. So thank you everyone, and here's hoping we have yet another great course. Thank you.
Thank you, Ms. Fene. May I now request His Lordship Justice Patel to kindly address our members.
It's always great to be back. And this advocacy thing, I don't know what I'm doing here, but never mind. Okay, I don't want to put you under pressure, but you are under pressure. Here's the bad news. The demands of advocacy, now this is the serious part of it, are actually fiercer now than they've ever been before. And that's because of the pressure on courts. Because judges are pressured for time and with volume, we've just got too much to deal with in too little time. They're looking for something else. They're looking for somebody who rises above in advocacy, and especially somebody who's able to get to the heart of it in like 30 seconds and hook the judge. Those days of long, expansive things are a thing of the past. Now, there's a difference between trial advocacy, which is what this course is about, and appellate advocacy, which is a subject for another day. And I do hope at some point that we are going to be able to tack on the appellate advocacy thing, because let me tell you, it's a very different thing from trial advocacy. And here's one example. Many years ago, I was one of those stringers in some major Alpic versus Sipla battle. Karsechi Cooper was on the other side. We were being led by Rohit Bhai. And we all wound up in appeal, Cooper's appeal. And at this table here, Rohit Bhai says to me and Vivek Devan, what are you two boys doing? So he said, we were just strolling to court. He says, don't stroll. Go and sit there and don't move. I said, why? He says, Dikra, you are not going to hear appellate advocacy like this too often. Go and listen to Cooper arguing one of the most difficult areas of contract law, anticipatory breach of contract. 2.5 hours before Justice M.R. Shah. And he boiled it down to something that a 9th standard student could have understood. It was one of the most extraordinary displays of appellate advocacy. It's been my privilege to hear. And the other one was Philly Vakil arguing a murder case coming out of Daman. His brief must have been 4-6 volumes like this. He didn't open it. He knew every page number, he knew testimony, he knew depositions. This is appellate from criminal trial, and he knew the material backwards. Now, what is the one common thread that happens here between appellate and trial advocacy? Which is the stage of final arguments? I'll just tell you what you should and should not do when you're going through the trial, because this is true of trials, it's true of, it damages your appeals, and it's true in arbitrations as well. But when you're arguing a final hearing, if you're for a trial, especially in a pressured court, if you're going to start with, in the High Court of Judicature at Bombay, you're going to put the judge to sleep. So you need to do this, and this is really, took me a long time to understand this. You have to be a storyteller. You have to have a narrative. And you have to have a narrative that gets the judge hooked into it. Which means that you have to learn in your narrative what you need to put in, and more importantly, what you need to keep aside. The leaving out is twice as important as putting stuff in. And the problem with advocacy, I find, is that everybody wants to cram in everything, including the draft and the advocacy. So the judge is thoroughly confused. You are saying this, but you're also saying that, but you're also saying this, and now you're interrupting. Very bad move. You have to have a narrative, your side of the story, because remember this, you've got one side, same facts, same law, you've got one side of the story, the opponent has another side of the story. The judge is going to decide which story he likes better. That's your job, and that's advocacy. Make it a compelling narrative. Now, to do this, you have to remember 2 or 3 things about trials. And the first is that trials are really, really scary. If you're not scared before a trial, you've done something wrong. You should be scared witless, because there are too many moving parts in this. You don't know what the witness is going to say. You have no idea what the other side is going to do. You don't know from what angle, what portion of the Evidence Act is going to come at you, or CPC. You had better be prepped for all of this. Now, I've had, as Nitin Bhai said, a disproportionate share of trials in this court, and I must tell you, some of them were just outstanding. So we got this rather portly guy who was in the middle of a messy divorce action, married in Mumbai, divorced in Ireland or Dublin or something, was fighting with the Bank of India at Kemp's Corner for retrieving some jewelry from some bank locker. So how this all got into a trial, I have no recollection, but it was an ungodly mess. At some point, there was a question about this guy's passport and the decree of divorce from Dublin. So in cross-examination, reasonable question was, can you produce your passport? Our friend looks at him, looks at me, and says, I refuse to answer on the grounds that I might incriminate myself. I said, one minute. This is not an Alan Shaw moment. You produce that passport or you're going to jail. 5 copies came out of his suitcase. The other was, I don't know, Nandini Menon's not here. Okay, poor Nandini was appointed as a commissioner in a copyright dispute where the plaintiff was Shubha Mutkal. She had performed at Spic Mackey in Madras, and these 2 tele-geniuses had gone and illicitly recorded this, put it out, and sold these bootleg recordings. So, copyright infringement damages and so on and so forth. Now, they were harassing poor Nandini and making allegations against her, so I said, stop it, all of you, come to court. So they came, 37. I had to sort of make sure that Shubha was able to fit inside that narrow witness box of mine. So I said, sit here. And the poor fellow was cross-examining her, but without, and this is a very important point, without a clue of where he was going with this. Now, the point I'm making is, do not ever cross-examine except to a defense. Don't ask questions and then expect to be able to raise a defense from the rubble of a cross-examination. And here's what happened. So he looks at Shubha Mudgal and says, Miss Mudgal, yes, do you agree that the videos my clients made of your concert were of good quality? I said, what did you say? She says, she's jumping up and down. I want to answer. I said, no, please don't answer. I asked him, are you sure you want to ask this question? He said, yes, it's a good question. I said, okay, ask. He asked. And she says, I agree they made a recording, but it was of very bad quality. End of shoot. End of the whole conversation. The only question was one of damages. This happened all the time. Somebody said that his film, had copyright in it, was illicitly broadcast on television by some channel. Cross-examination. On what basis do you say it was broadcast on my client's channel? Nowhere in any material. He said your client's logo was on it. Thank you very much. Sit down, decree. Now be very careful about this, and we learned this in a trial that cross-examination can actually be a binary. You start listing what we used to call proofs. Much easier to do now on computers. In those days, we used to do them by hand. Frame the question and decide whether the witness is going to say yes or no. If the answer is yes or no, don't ask it, unless it doesn't make any difference to the result. Once he answers yes or no, you have your next options of if he says yes, then ask this. If he says no, then ask that. Now, the reason I'm saying this is that if you don't do this, your later stages, all the way to the appeal, are in great jeopardy and in great difficulty. Trial advocacy is possibly the most challenging thing that you can do. Janak said this a long time ago. He says you learn more in one trial than in 100 motions. And that's actually true, because you get to see so much of law coming into play in trials. So if you ever get the chance to do a trial, and don't wait for trials to happen in the Bombay High Court, it's the wrong place to look for them. Arbitration, small causes court, city court, wherever they're doing a trial, city courts pumping them out, get a brief and get there and do the trials there. Many of our judicial officers have spent a lot of time doing trials, so they're really quick with them. Be very careful about the way you have your evidence noted. I did it in the normal style earlier, paragraph formats for the examination chief. I found that very difficult, because sometimes question and answer is determined, an answer is determined by the way the question is framed. So the framing of the question is crucial to the answer. And this is something that I realized which very few people really understand. And please appreciate how burden shifts depending on the way you put a question. The moment you say, I put it to you, there's a problem. Is it correct? Now, is it correct suggests that you know that the statement you're making is in fact correct, and you're in a position to prove it. If you put a case, it means you're in a position to do this. You don't have to cross-examine on every statement made everywhere. But be very careful when you start putting a case to somebody, or when you are making a suggestion, saying, it's one thing to say, for example, is it your case that? You're only trying to find out what is it that he is saying. But it's different if you say, do you agree? I put it to you. Is it correct that? And again, if you get a chance to see one of these classic masters, I had the privilege of seeing both Cooper and Rohit Bhai in full cry in trials. And one of Rohit Bhai's questions, I remember, was so carefully crafted that the judge said, just wait a minute, take down the question. Then he said, don't answer. So I said, Rohit Bhai, what's going on? He said, he's thinking about the question. I said, absolutely correct, because the question was super loaded, but was constructed in a way that the only answer that would happen was in Rohit Bhai's favor. But you have to construct the questions accurately, and please, if you're going in appeal, make sure that the questions get recorded as they should. This is going to be very, very difficult. Okay, listen, I've taken too much of your time. You have to get back to other stuff. This seminar has to start. Or you're doing it over the weekend. You're starting over the weekend. All right, good luck. Hopefully we'll be able to expand this, and maybe I'll be able to come back in some other capacity. Thank you very much.
I would like to sincerely thank Justice Patel for having accepted our invitation and for being here with us. Thank you to all our trainers, because of whom this program and training schedule is possible. Thank you all the participants for being here with us. This concludes our function. Please join us for tea and snacks.